everybody. Let's wait for others to join. I would request everybody to join like on time.
Good evening, ma'am.
Good evening. Good evening. Okay, so let's revise what we studied yesterday. We were dealing with the concept of restitution of conjugal rights, as we already saw that it is a substantive relief granted under the Hindu Marriage Act and has been dealt under Section 9. Okay. And we have borrowed this concept from Jewish law, and it is an important question from prelims point of view as well. Okay. So as far as the essentials are concerned, so what is there is, we discussed that there are certain marital obligations which the spouses have to fulfill and they have towards each other. And in case there's a breach of these marital obligations, especially of right to consortium, which we talked about, right to each other's society, to give comfort, and affection to each other. So if there's a breach of this marital obligation, the legislature gives a relief to the spouse, whereby the spouse can approach to the court for a decree of restitution of conjugal rights. What does this mean is that the spouse will approach the court stating that the other spouse has withdrawn from my society and there does not exist any reasonable cause for such withdrawal. And what I'm saying is the truth. Okay, so please grant me a decree of restitution of conjugal rights and ask the spouse who has withdrawn from my society to come back to me. And the court will grant the decree of restitution of conjugal rights if all the essentials have been fulfilled. So what are the essentials? Essentials are that there has been withdrawal from the society of the petitioner, okay, and there does not exist any reasonable excuse for such withdrawal. This means the respondent has withdrawn from the society without any reasonable excuse. Aise hi, okay, and the court is also satisfied that the statements that are made by the petitioner are true, and also there does not exist any other ground on which the court may refuse such relief. Okay, then we proceeded on to discuss in detail the meaning of the term withdrawal, and then we also dealt in detail the meaning of reasonable excuse, right? And in withdrawal, we analyze there must be an element of desertion, right? And we must have two elements altogether existing coexisting with each other, animus and factum, which is intention to put cohabitation to an end, and factum is fact of separation. Okay, and they both must exist at the same time, although each of them may start at different point of time, but for desertion to exist, they must be existence at the same time. And then we proceeded on to discuss about the term reasonable excuse, whereby we dealt with the concept of matrimonial home and how this concept has changed because of advancement in technology, education, new opportunities, employment opportunities, and women being more career conscious and women taking up jobs both before marriage also and after marriage also, and especially in cases where women take up job outside the city where there's the matrimonial home, right? So let's proceed. Okay, before we proceed further, we also dealt with that the burden of proof that whether the withdrawal is with reasonable excuse, the burden of proof lies on the respondent. Right? Now, before we proceed on to further about constitutional validity, it is important for us to first understand that what happens if a decree of restitution of conjugal rights is not obeyed. Okay, so let's understand a case. There's a husband and there's a wife. The wife has withdrawn from the society. Okay, and the husband obtains a decree of restitution of conjugal rights. Okay, so what does this mean? That the court has asked the wife to return back to the husband and live together with the husband, right? So what if the wife does not obey this decree? So what will happen? See, have you guys done CPC, civil procedure?
No, ma'am.
Okay. So in Code of Civil Procedure, Order 21 deals with execution of decrees. The procedure how a decree has to be executed has been dealt in detail under Order 21. Okay. And Order 21, Rule 32 and 33 talk about execution of decree of restitution of conjugal rights. Okay. Fine. So what does these rules say? This provides that if a spouse who has been asked to return back to the society of another does not do so, or simply we can say that does not obey the decree of restitution of conjugal rights, then the court has power to attach the property of the spouse who does not obey the decree. So in this case, what will court order is, court will order attachment of property of wife. Okay. And if the wife does not still obey the decree, then after 6 months of attachment, the court will order sale of this property. Okay. And out of the sale proceeds, the sale is done by auction. And out of the sale proceeds, the court will grant to husband compensation as it deems fit, and rest of the money which is left after giving compensation to the husband in this case, rest of the money will be given back to the wife. Clear? This is how the decree of restitution of conjugal rights is executed. Fine. But there's a saying in English that you can take the horse to the water, but you cannot make him drink water. Okay. And this is very much applicable to a decree of restitution of conjugal rights. Okay. So although the court may grant a decree of restitution of conjugal rights, okay, but it cannot still force the other spouse to go back and start living and resume cohabitation with the petitioner, right? So what option does the husband have in this case? Okay, let's say the wife's property has been attached also and then sold also, and still wife does not return. So ultimately, what remedy still the husband has? The remedy lies in section 13(1)(a), which is a which talks of divorce, okay? And it incorporates the theory of breakdown of marriage. Breakdown of marriage is very much clear. The terminology is very much clear. As in this case, the court has also resorted to its last means, okay? And still the wife does not wish to return. So this means that their marriage has completely broken down and there is no hope for returning back, right? So in these cases, either the husband or the wife, it is important to note that both husband and wife have a right to approach the court after 1 year of passing of decree of restitution of conjugal rights to ask for divorce if this decree remains unsatisfied. Okay, so after 1 year of passing of decree, if spouses do not resume cohabitation, the remedy lies is that either of them can approach the court for divorce under section 13(1)(a) on the ground that their marriage has been broken down completely and this decree has remained unsatisfied. Clear till here? Clear? So, an important question for prelims is that both husband and wife have a right to approach the court. Okay, so both of them can approach the court. The wife will say that I do not wish to go back because our marriage has broken down and the decree has remained unsatisfied for a period of 1 year, and the husband also says the same thing. Okay, so they can get a divorce on this ground. Okay, so now let's move to constitutional validity. So the very first important case is of T. Saritha versus T. Venkata Subbayya. This case is of 1981, Andhra Pradesh High Court. Okay, the Andhra Pradesh High Court took a stance that this provision is not constitutionally valid. And it gave an elaborate reasons as well. It termed this provision, this section, as highly uncivilized, an engine of oppression, as well as barbarous. And why so? It gave the reason that right to cohabit, which is available to every human being, okay, is ultimately passed from the domain of individuals I'll move to the previous slide, wait, to that of the state. And also, since this decree is capable of being executed, So ultimately, what's happening is that you're forcing, you are coercing the unwilling spouse to have sexual cohabitation, that too through a judicial process. And hence, this provision is violative of Article 19 and 21 of the Indian Constitution. Okay, so this judgment took a stance that this provision is not constitutionally valid. And you get a question from in prelims on this thing only, that which particular judgment took a stance that this provision is not constitutionally valid. Okay, I'm repeating again. Okay, the court, the Andhra Pradesh High Court, termed this provision as highly uncivilized, an engine of oppression, and barbarous. It stated that right to cohabit, right to establish.
Can you go a bit slow, please?
Sure. So, what happens is Article 19, what does it talks about? Freedom of speech and expression. And Article 21 is right to life. And by virtue of these two articles, you have a right to sexual autonomy. It is on everyone. Everyone has a right, whether one wishes to cohabit with the spouse or not. And this particular section is violative of these fundamental rights, because ultimately, by a decree of restitution of conjugal rights, what the court is asking you to do, the court here, the case that we just discussed, is asking the wife to go back to the husband. Okay, and go back to the husband. What does it mean? Right to cohabit with him. You have to cohabit with the husband, and right to cohabit means to develop sexual relations with him. And despite the fact that she was unwilling to do so, the court, through the judicial process, is forcing her to do so. And ultimately, this particular decree is violative of Article 19 and Article 21. In these particular cases, women are being denied the right to decide whether, how, and when her body should become a vehicle for procreation of children. So if you ask the wife to return back to the husband, okay, so first of all, she's being denied the autonomy to have or to decide whether to have or not to have sexual relations. Secondly, when to have them and how to have them and with whom to have them. Okay, so it is violative of Article 19 also and Article 21 also. Are we clear on this judgment? Is there anything that you did not understand about this judgment?
Ma'am, won't we discuss the facts of the case?
No, that's not important for you to know them. Okay, it is only important for you to know what did the court held. The facts of the case are not relevant for you from the examination point of view. Okay, but it is very much important to know that what stance was taken by the judiciary And why was that stance taken? What was the reason given by them? Clear till here? Okay, let's move to another case. This is of 1984 Delhi High Court. Delhi High Court term held this provision as constitutionally valid. And the reason given by the Delhi High Court was that, see, this decree is two in one ship. Okay? By the virtue of this decree, the spouses get to know they have two options. If the decree is followed or if the decree is obeyed, the parties ultimately start living together and it preserves the marriage. Right? And if this decree is not obeyed by the spouses, this means their marriage has broken down and they have reached a stage of no return. And in such cases, by virtue of section 13(1)(a), they can approach the court for divorce. So ultimately, where in certain cases it does preserve the marriage, and in other cases where it becomes necessary to get rid of the marriage, it gives the parties an option for that also. So it states that there's nothing coercive about this. About this decree. The parties still have an option not to obey the decree. Right? And the proverb that I was using, that you can take the horse to the water, but you cannot make him drink. This is applicable to this particular section, and we can say that this stance was taken by the Delhi High Court. Okay, although there might be certain elements by which the court may require them to obey the decree, but ultimately the autonomy lies with the parties, whether to continue the marriage or not to continue the marriage. Clear about this thing also? Clear? Why is the class very
Yes, ma'am, clear.
very quiet today? Okay, perfect.
Clear, ma'am, clear.
So the third judgment is of Saroj Rani versus Sudarshan Kumar. This is also of 1984, but this is a case of Supreme Court. The Supreme Court favored the stance taken by the Delhi High Court and held this provision as constitutionally valid. We can visit the slides later on. Okay, so the Supreme Court also held this provision as constitutionally valid, and it stated that no doubt, Order 21 talks about attachment of property, but that is just an allurement for the parties to reconcile. Do you guys understand the term of allurement? Okay, I'll explain you the term allurement by giving you a simple example. while there is sale in a mall, people go and shop a lot. Okay. And why do they shop a lot? Because there is a reduction in the prices. So we say that the things are at alluring prices, which induces you to buy. Okay. So this kind of attachment, the provision for attachment is kind of an allurement कि अगर आप ऐसा नहीं करोगे तो आपकी प्रॉपर्टी आपके हाथ से चली जाएगी. So जैसे बच्चे को टॉफी लेके कुछ भी वो करवा सकते हैं ना. So this is a kind of allurement that the court gives you to reconsider your stance again. Okay. And to reconciliate and ultimately preserve the marriage. And the stance that was taken by the Supreme Court, if you notice, this was a stance taken in 1984. And according to the times prevalent at that time, I think and I believe that the Supreme Court was very much right in taking that stance, because our society had not developed whereby it could have declared this provision as not valid, constitutionally not valid. But currently, this provision is still under consideration. And let us see when and what stance does the Supreme Court now take, whether it declares it as constitutionally valid or constitutionally not valid. Clear till here? Clear?
Yes, ma'am.
Yes, someone has a doubt? Kusum, what's the doubt? Okay, no doubt. Shall we move ahead?
Yes, ma'am.
Okay, so if we make a synopsis, so by far restitution of conjugal rights is concerned. So we first understood the meaning. Okay. Then we also discussed its object. Then we proceeded on to discuss its essentials. Okay. Then we discussed about burden of proof. Then we discussed the terms withdrawal and reasonable excuse. Then we proceeded on to discuss that an alternative remedy is of divorce. Right? And then lastly, we discussed the constitutional validity. Okay, one more thing. As far as this point is concerned, alternative remedy of divorce. So if we take this case only, whereby the husband approaches the court and asks the wife to come back. Okay, the wife, it is not necessary ki only after passing of decree of restitution of conjugal rights and waiting for 1 year after that they can approach for divorce under section 3(1)(a). Okay, when the husband approaches the court for decree of restitution of conjugal rights, the wife can say, she can put forward her facts, her side of the story, and ask for divorce as well. If, let's say, the husband used to treat the wife with cruelty, and the wife, for this particular reason, withdrew from the society of the husband and started to live separately. Okay, so in a suit instituted by the husband for decree of restitution of conjugal rights, the wife, in the alternative of this, can ask for divorce on the ground of cruelty. Clear about this thing? Clear?
Yes.
Okay, so let's move on to another substantive relief. We'll again draw this chart. Relief, the substantive reliefs, and then there are ancillary reliefs. So substantive reliefs, 9, in section 9, we have restitution of conjugal rights. In 10, we have judicial separation. In 11 and 12, we have decree of nullity. And in 13, we have divorce. Okay, so we are through with section 9 and we have also done decree of nullity, right? So let's proceed on to this substantive relief, which is of judicial separation. So in restitution of conjugal rights, what was happening was that one of the spouse withdraws from the society, and ultimately what relief is the spouse asking from the court? For reconciliation, right?
Yes, ma'am.
But in judicial separation, the spouses approach the court and ask the court that we will live separately, but we will not get divorce. Okay, we will live separately, we will not get divorced, and our marital obligations, please suspend them for some time. Will not be performing our marital obligations so that we get an opportunity to piece our lives together. To see what went wrong in our relationship and how can it be fixed. Also to decide whether it can be fixed or not. Okay, so in a decree of judicial separation, the spouses approach the court and they say that we regard divorce as something not right, and it is a very extreme step that can be taken. Okay, and before resorting to divorce, you grant us a decree of judicial separation. And for this particular time, we will live separately. We will not cohabit with each other. Okay, and our all marital obligations will remain suspended. And during this time, when such marital obligations remain under suspension, we'll figure out whether we can live together. If we can live together, we'll approach the court again and we'll ask you to rescind the decree of judicial separation so that we start living together again. And in case we are of the view that we cannot live together, then you grant us divorce. Clear? Are we clear with the meaning? We'll discuss in detail for how long is this decree valid. Okay? So, we have understood the meaning. We have also understood the object. So, there is always an element of reconciliation possible. The parties, they believe that, if we live separately for some time, it will give an opportunity to the spouse who's generally at fault. Ayush, I'll move the slides later on, okay? You understand the concept. The spouse who's at fault, if he lives separately, he or she will get an opportunity to understand the fault and to work upon it, and to ultimately reconcile if it's possible. Okay, so as under decree of restitution of conjugal rights, same is the case with judicial separation also. As in, if this decree, after decree of judicial separation, if parties or spouses decide not to cohabit, then either of them can approach the court for divorce under section 13(1)(a) after 1 year lapse of the decree that our marriage has broken down and there's no element of reconciliation possible, and you grant us the divorce. Clear till here? Are we clear till here?
Yes, ma'am.
Yes, ma'am.
Okay. So now let us, go through the time when such decree is still in force. Okay. So we said कि decree grant कर दी court ने of judicial separation. Okay. I said the parties have two options. They can continue the marriage, and they can put an end to marriage. Right? We discussed the case that how can they put an end, that after 1 year of lapse of the decree of judicial separation, they can approach the court for divorce under section 13(1)(a). Okay. But if they wish to continue the marriage, okay, so they will have to approach the same court again and tell the court or ask the court to rescind the decree of judicial separation that was earlier granted by the court. So, and why is this necessary? Because decree of judicial separation का मतलब क्या है? The court is giving you the freedom, or you can say the right, to live separately and do not perform any marital obligations. So you have to approach the court again that we are ready to live together again, and please cancel this decree. And we'll again live together, we'll cohabit with each other, and we'll also perform the marital obligations. Okay. So what are the grounds of judicial separation? On what grounds can the spouses approach the court for a decree of judicial separation? So if you consider the grounds of divorce under section 13, there are certain grounds which are available both to the husband and wife. And then there are certain grounds of divorce which are only available to the wife. So the grounds of judicial separation and divorce are common. This means that the husband can approach the court for judicial separation on any of the grounds mentioned under section 13 subsection 1, and the wife can approach the court for judicial separation on any of the grounds mentioned under either section 13 subsection 1 or section 13 subsection 2. Okay. And while we do divorce in detail, we'll discuss what all grounds have been mentioned under these subsections. Okay. As far as now is concerned, you all need to know that grounds of judicial separation and divorce are common. Clear till here? Clear?
Yes, ma'am.
Yes, ma'am.
Okay. So let's say, so what is the difference between judicial separation and divorce? A decree of judicial separation does not end the marital tie, but a decree of divorce definitely ends the marital tie. Ayush, I will move the slides, okay, and you can take down the notes. Do you think am I fast and you're not able to grasp what I'm saying? Is this the case? Okay, maybe then I'll move a bit slow, or maybe I can show you the slides later on. Okay.
Ma'am, your speed is perfectly normal and we are understanding all the concepts.
Perfect. So, Ayush, I will move the slides. You don't have to worry about noting it down, okay? We are just about to finish judicial separation and then we'll move to the slides. So, judicial separation, a decree of judicial separation, it does not put an end to the marital tie, but a decree of divorce does put an end to the marital tie. Okay. Then we have to understand two important circumstances. Okay. First of all, while a decree of judicial separation is under force, is effective, since the marital tie has not come to an end, either of the spouses cannot contract second marriage. Because their first marriage is very much subsisting and that marital tie has not come to an end. Clear about this thing? Secondly, now let's take the case of section 376B IPC. Have you studied this section? Have you guys studied this section? 376B of IPC? Okay, let's discuss it. It talks about if husband and wife are living separately, and such separation may be either through a decree of judicial separation or otherwise. Let's say they've fought with each other and they're not living together, they're living separately, but they have not obtained the decree of judicial separation. Okay, so they're living separately, and the husband, if he has sexual relationships or sexual intercourse, I would say, with the wife without wife's consent, then he'll be guilty of rape. Okay, and he will be liable to punishment which may range from 2 to 7 years, and he'll also be liable to fine. Clear about this thing?
Please repeat.
Okay, so if the husband and wife are living separately, okay, whether under a decree of judicial separation or otherwise, and the husband tries to have or has sexual intercourse with wife during such separation, without wife's consent, the husband will be guilty of rape under section 376B of IPC, and he'll be liable to punishment which may range from 2 to 7 years and fine. Anything that is not clear?
Clear, ma'am.
Clear, ma'am.
Ma'am, what is the meaning of otherwise here?
Otherwise, see, there was a question in prelims recently on this otherwise only. So there are a lot of cases whereby the husband and wife are living together, where the husband and wife, they're living separately. They do not live together. I mean, their relationships are not cordial. But they have not obtained a decree of judicial separation from the court. In such cases also, if husband has sexual intercourse with wife without wife's consent, then he'll be guilty of rape. Okay? The essence is that they're living separately and they are not having cordial relationships. See, you have to understand that not in every case the parties approach the court. There are very few cases that reach the court. Okay? If the marriage is not going on smoothly, first of all, not every case reaches the court, and not every spouse or are happy with the fact to obtain a decree of either divorce or either judicial separation. So this particular section covers both the cases, whether they have obtained the decree of judicial separation or whether they have not obtained the degree of judicial separation. Clear about this thing?
Ma'am, won't
Yes,
this
ma'am.
amount to marital rape? Like, if then
yes.
marital, yes, ma'am.
Yes.
So that should means what is the difference if
See,
in
that is a forte of IPC more, okay? And then that you can discuss in IPC classes, okay? But this section 376B IPC does not cover all cases of marital rape. You know how? Let's say the husband and wife, they are living together and their relationships are also very, very cordial. Okay? And the wife does not wish to have sexual intercourse, but she does not have the authority to say no. In such cases, this particular case will not fall under 376B IPC. And she cannot approach the court anywhere under any of the provisions. Are you able to understand? When they are living together and their relationships are cordial, then the wife cannot say a no to have not to have sexual intercourse with the husband. And that is why there are speculations of making it as a separate offense. Are you clear, Medha?
yes, ma'am.
Okay. So are we clear about judicial separation as well? So what are the
Yes,
important
ma'am.
points that you have to remember? First of all, we understood the meaning we understood the object, right? Then we proceeded on to discuss about rescission of the decree. We also discussed the grounds which are common with divorce. And then we discussed the cases where decree of judicial separation leads to divorce under section 13(1)(a), right? And lastly, we discussed about the cases, two important aspects where decree of judicial separation is still in force. So this is all we have discussed. Are we clear about it? Any doubt in any of these things? Any of the aspect that we have discussed?
No, ma'am, clear.
Okay. So that's all for today. And for the people who wish to write, I'm moving the slides. Okay. And rest of you, if you wish to stay, you may stay. And if you wish to leave, you may leave.
Ma'am,
You're welcome. Yes, Archie.
ma'am, you were telling the difference between judicial separation and divorce. Do we have to add any more points in that? Or the first point is enough for this?
See, the major difference is this only, that, what do you understand by this term? Let's move. There is no end to marital tie, right? In judicial separation. So this means consequences of valid marriage will flow. Right? What does this mean? If any child is born between this period when the judicial decree is still in force, the child would be legitimate one. Okay. So, and if suppose during judicial separation is in force, either the husband or the wife dies. So since there is no end to marital tie and the marriage is still valid and subsisting, the other spouse will inherit the property of another. See, all the consequences of valid marriage will flow. And these consequences we have already discussed under, I guess, voidable marriages, if it is not annulled. Right? So all the consequences of valid marriages will flow. But all you have to, the major difference is that in one case the marriage ends and in another case the marriage does not end. This is the major difference that you have to keep in mind. Are we clear, Archie?
Yes, ma'am. Thank you.
You're welcome. So let's move to the slides.
Slides of judicial separation.
Ayush, first of all, your voice is not clearly audible. Maybe you can type the message and send to me.
Ma'am, could you please show the slides of judicial separation?
Okay. And in next session, we'll proceed to divorce. Okay, we're moving to slides of judicial separation. So tomorrow we'll go on to divorce. Okay, we'll understand, and how I wish to proceed with divorces. We'll do the grounds of divorce, and then after doing all the grounds, we will try to make a broad headings under which we can club them all together.
Ma'am, can you please provide with some important case laws for judicial separation also, or the other main topics that are prevalent from the mains point of view?
Medha, what I am doing is, wherever it is necessary for you guys to note down any case law, I am doing it. Okay. It is not that कि judicial separation का कोई case law नहीं है हर टॉपिक के बहुत केस लॉज मिल जाएंगे एंड आई कैन मेक यू राइट ऑल्सो बट दोज आर नॉट इम्पॉर्टेंट फॉर यू टू रिमेंबर ओके एंड दोज आर नॉट इम्पॉर्टेंट फॉर यू from either prelims point of view or from mains point of view. And if you guys still wish to write them, you are like, I'm more than willing to do that. Just let me know if you are willing to do that, because jo bhi material that I am discussing in class, whether it is case law or whether it is about all the aspects of topic that we are discussing, that is enough, more than enough, from prelims point of view as well and from mains point of view as well. And इससे ज्यादा कुछ करने की जरूरत नहीं है. So if you're still willing that कुछ ना कुछ तो case law लिखवा ही दो, then I will make you write it. Just let me know if you want that.
Okay,
You know what
ma'am.
happens
Thank you.
at this particular time, okay, since you guys are learning, you may write all the case laws, but when you have to club them all together at the time when the exam is approaching, तुम्हें वो चीजें याद नहीं रहेंगी. So what my aim is to make you write what is important and वो ही याद रखो. So Medha, let me know, tell me right now whether you wish me to make you write other case laws as well.
No, ma'am, if it is important to do so, then only, ma'am.
No, जो मैं डिस्कस करा रही हूँ उससे बाहर नहीं होगा.
Okay.
Yes.
Ma'am, wait.
Yes, Ayush.
Ma'am, previous line.
Okay.
मैम एक सजेशन था.
Yes, definitely.
मैम, आप जब बताते हो ना, जब राइट करते हो आप बोर्ड में,
हाँ जी.
हम अगर आप थोड़ा सा स्लो बोलोगे ना, तो आपके साथ साथ हम लोग भी लिख लेंगे, तो आपको लास्ट में दिखाना नहीं पड़ेगा.
Okay, Ayush, I will do that from tomorrow onwards.
थैंक यू.
Okay, thank you so much. Have a nice evening.